I'm going to cover payment issues, and what we're going to talk about here in my section is some case law that came down last year involving what I'll call CASPA, which is the Contractor and Subcontractor Payment Act, and I'll explain that in more detail in a second, under Pennsylvania's Commonwealth Procurement Code and under the Federal Miller Act, okay, dealing with posting of payment and performance bonds on federal projects. This is something, these topics are something we hit every year because we think it's that important to the construction industry. For 2014, there were no changes to the substance of any of these statutes, either the Contractor and Subcontractor Payment Act, the Commonwealth Procurement Code, or any of the applicable bond laws, whether it's Pennsylvania's Little Miller Act or the Federal Miller Act. But like I said, there are three cases I wanted to discuss. One deals with a very important provision contained within CASPA. Okay? One deals with an interpretation of a very important provision within the Commonwealth Procurement Code. And the third case deals with how a pay-if-paid defense, a pay-if-paid clause in a contract, was handled by a federal court in interpreting a claim under a Miller Act payment bond. Okay? My personal opinion, just mine, is that the case which addresses and interprets one of the provisions of the Contractor and Subcontractor Payment Act is probably the most important, probably the most interesting case of the three. I think it's the one most relevant to many of us in the room. So I thought it might be appropriate to just take a couple seconds to talk very briefly, kind of in general, about what CASPA is, to give some context to the discussion of that case. Again, as I mentioned, I keep calling it CASPA to save my voice, but CASPA is an acronym for the Contractor and Subcontractor Payment Act. This is a Pennsylvania statute which applies to construction contracts to perform work on real property in Pennsylvania with only a few exceptions. The exceptions are when CASPA is preempted by the Commonwealth Procurement Code. And the Commonwealth Procurement Code applies to contracts, construction contracts with Commonwealth agencies, okay, and with other forms of public entities, which are defined as governmental entities in the code, for instance, school districts, okay? The only other time CASPA is not going to apply to a construction job on real estate in Pennsylvania is if the contract relates to 6 or fewer residential units. So if you're working on a commercial project in Pennsylvania and the owner is not a public agency or a Commonwealth agency, CASPA is going to apply. And this is a really, really important statute for owners, but especially for contractors, because this statute was enacted, the intent of the statute was to benefit contractors. All right, and it has a number of important remedies that construction lawyers like to argue about and even fight about all the time. CASPA contains, first of all, payment terms as between the owner and the general contractor, unless those payment terms are otherwise negotiated in the contract. And importantly for contractors, especially subs, it requires that general contractors must pay its subcontractors, and those subs must in turn pay their own subs the later of 14 days from receipt of payment or the date of the invoice is submitted. Now, importantly, the Act requires that for a contractor, a general contractor, to rely on a pay if paid or a pay when paid clause, that contractor must first disclose the dates of payment from the owner, and that disclosure must happen before the subcontract is executed. The Act does allow for both owners and general contractors to withhold money for so-called deficiency items in the work, but it requires that notice of those items and a description of those deficiency items be provided within 7 days of receiving the payment request. So theoretically, if that 7-day window is missed, the owner or the general contractor has waived its right to withhold payment for deficient work by the sub. CASPA also contains specific provisions addressing how and when retainage has to be dispersed. And then perhaps most importantly, CASPA has different levels of remedies for a violation of the Act. All right? First of all, it provides that unless the contract otherwise states amounts which should have been paid but were not paid, and therefore where CASPA has been violated, will bear interest at 1% per month. Okay? If you have to sue to get your money or file an arbitration to get your money, on top of your interest, you get an additional 1% per month. Finally, if you have to sue or file arbitration and you win to get your money, the Act requires that the court shall award attorney's fees. Okay? So theoretically, if you're a sub, say, and you're not paid your money, and the owner or the general contractor has violated CASPA, you get your money plus 24% interest and penalty interest plus your attorney's fees. So it's a pretty powerful form of leverage in these types of disputes. Now, one of the things that's in CASPA that is the subject of the first case discussion is a provision that is found not just in CASPA, but in almost every state's version of a Prompt Pay Act. CASPA says in one of its sections, I've got it in a later slide here, that an attempt to make the law of another state apply to a contract, or an attempt to force the parties to the contract to litigate or arbitrate their disputes in another state shall be void and unenforceable. Obviously, the intent of the statute is to protect Pennsylvania contractors doing work on Pennsylvania projects. If you're a small contractor in Allegheny County, you shouldn't have to go to Missouri to litigate or arbitrate your dispute on a Pennsylvania project. Well, this case, I said this is the most important case. I think this one's interesting and I believe very important. K&L Construction versus Killian Construction. It was a case decided in federal court in the Middle District of Pennsylvania. And in this case, Killian was the general contractor hired to work on a Mohegan Sun casino project in Luzerne County, Pennsylvania. They hired K&L as a sub, and K&L was a local Pennsylvania subcontractor. The parties signed a contract which contained a forum selection clause, and that clause has been reproduced here. And as you can see, the forum selection clause says Missouri law is going to apply, and if we have a dispute, we're going to litigate as between the two parties in Missouri, in either state or federal court or in Missouri. Obviously, that clause is there because K&L Construction was from Missouri. So a dispute arose between the parties, and the Pennsylvania sub, filed a lawsuit against the general contractor alleging breach of contract and alleging a claim for the remedies that CASPA provided. And here we've reproduced the section of CASPA that I mentioned, which very simply states in clear terms, making a contract subject to the laws of another state or requiring arbitration or litigation in the other state shall be unenforceable. Okay? Killian, the general contractor, sought to dismiss the Pennsylvania lawsuit based on the forum selection clause in the contract, which says, hey, we have to go to Missouri. Okay? Who won? What controls? Well, the federal court in the Middle District of Pennsylvania held that the forum selection clause in the contract, which called for Missouri law to apply and for the case to be heard in Missouri, trumped the language of Pennsylvania's statute. Okay? And they essentially found that a forum selection clause agreed to by parties in an arm's length negotiation is entitled to controlling weight in all but the most exceptional cases. The court went on to rely on a United States Supreme Court decision, which just came down in 2013, to find that to overcome the presumption of the forum selected in the contract, the plaintiff needed to show a compelling public interest consideration. And the poor subcontractor from Pennsylvania says there is a public interest consideration. The statute, or the legislation of Pennsylvania thought enough to protect guys like me, they enacted CASPA. We have a statute that tells us that what is happening here is void and unenforceable. What could be more compelling than that? The court didn't buy it. Okay? Dismissed the case, moved the case to Missouri. And I said the court was relying in part on a United States Supreme Court case from 2013, and that's this Atlantic Marine construction case. And basically what that case stands for is the idea that the United States Supreme Court kind of weighed in on forum selection clauses and has basically said, look, if the parties are going to agree to something in a contract, specifically on where they're going to have their disputes, there's got to be a really strong public policy reason why we're not going to enforce that. This, in my view, is horrible news for Pennsylvania contractors. This is something that construction lawyers have used for many years. We represent lots of contractors and lots of subs, okay? We've all had situations, I'm sure, where I've represented a Pennsylvania contractor who has entered into a general contract with some GC from Texas or Oklahoma or Missouri, and a dispute has arisen, and they want to rely on that clause, and we've said, no, 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 you can't do that, go read CASPA. And then we have the case here, or we settle the case, or whatever. This is especially important right now, given all the outside influences in Western Pennsylvania doing work on Marcellus projects and elsewhere. All right, if you're a sub and you get a contract from a company in Oklahoma to work on a Marcellus project that involves some work to real estate, arguably CASPA is going to apply. Okay, you don't have the protection now where if somebody doesn't pay you the last $100,000, you can't run down to the courthouse in Greene County or Washington County and sue them. You may have to go to Missouri now or Oklahoma. So it's a big change in the law, and it's one that's certainly going to impact lots of contractors here in Pennsylvania. My last note on this issue at the bottom of the slide, even though that section of CASPA I mentioned has always said that an attempt to make litigation or arbitration occur in a state other than Pennsylvania is unenforceable, the arbitration part of that has, for many years now, been recognized to not necessarily be enforceable because the Federal Arbitration Act preempts the application of CASPA. So this is not new news in terms of arbitration, but it is new news in terms of litigation. The second case I wanted to mention is U.S. Glass versus XLE Metals versus Ronald Dwayne Patterson. And I mentioned we had a case that dealt with CASPA. That's the one we just talked about. We have a case that deals with the interpreting the Commonwealth Procurement Code. That's in a minute. This is a case that's talking about interpretation of the law as it applies to payment bonds under the Federal Miller Act. Okay. The Federal Miller Act applies to contracts awarded for construction projects, basically, for any public building or public work of the federal government. And the Miller Act requires that if you've got a construction contract on a federal job for more than $150,000, the general contractor has to post payment and performance bonds that apply with the requirements of the Federal Miller Act. In this case, the government hired GC Aeroplate Corporation as its general contractor to do some work on a VA medical center in Philadelphia. Okay. Aeroplate posted its bonds that it was required to under the Federal Miller Act, and Ronald Dwayne Patterson is not a person, it's a company, but was the surety for Aeroplate in this instance. Ronald Dwayne Patterson posted the bonds. Aeroplate hired U.S. Glass Company as a subcontractor on the job. And a dispute arose, and U.S. Glass filed a lawsuit for breach of contract and as a claim against the Miller Act payment bond in the federal court in the Eastern District of Pennsylvania. For whatever reason, they were able to settle some part of their claim, and they settled out with the general contractor, but claims against the surety remained. And in the contract between GC Aeroplate and U.S. Glass, there was a so-called pay when paid provision. Probably everybody in here knows what that is, but it's a common provision found in some construction contracts. It basically says the general contractor doesn't owe any money to the subcontractor until it gets it from the owner. Okay? Pay when paid. And the language from the pay when paid clause in this case is reproduced here. The surety's only defense, apparently from a reading of the case, there was no problem with the work and services provided by the claimant. You know, they weren't arguing about whether the work or products were deficient. The only argument really was that the surety defended itself on the basis that the government never paid its principal, the general contractor, for the work that U.S. Glass actually performed, and therefore the surety can't be liable to the claimant. On a basic legal principle, this is right? Because sureties generally get to rely on the defenses of their principal. And a pay if paid clause is valid under the substantive law of Pennsylvania. But that was their only defense. The surety defended on the basis of pay if paid. Hey, we didn't get the money. U.S. Glass moved for summary judgment on the issues, and the court, in the summary judgment stage of the case, had to squarely address this issue of whether a contractual pay when paid clause can be a valid defense to a Miller Act claim. Okay? In their analysis, the court went through what it is a contractor has to do to establish a valid Miller Act claim, and it has to prove it supplied labor and materials, that it hasn't been paid, that the materials were either used in the project or they had a good faith belief they were to be used, and that the jurisdictional requirements were met. Here, the claimant easily met those elements of the case. And so the court found that the pay when paid clause, while valid under Pennsylvania law, was not a defense to the Miller Act surety. They found that enforcing that defense in the context of a Miller Act claim would defeat the entire purpose of the Miller Act. The Miller Act is there to ensure people providing work or materials on a federal project get paid for that work. A secondary argument in the case was that there was language in the contract addressing whether the right to be paid, the right to make a claim under the Miller Act was waived or not. And the court disposed of that very quickly because the Miller Act specifically addresses how waivers of rights under the Miller Act are handled. And a waiver of rights under the Miller Act claim are only valid and enforceable if they're in writing, signed, and executed after the person has done their work. So there's no such thing as an upfront waiver in a federal Miller Act scenario. This is not a shocking result, okay? But it's important. We thought it was important because it was the first case applying Pennsylvania substantive law which specifically held that a pay if paid is not a defense to a surety. And it's in contrast with Pennsylvania law on payment bond claims on private projects. In our year in review a couple years ago, we spent a lot of time talking about this Sloan versus Liberty Mutual Insurance case. That was a case decided by the Third Circuit, okay? The appellate court above the federal court that decided this case. And in that Sloan case, what the court held is on a private construction project, a surety has all of the defenses of its principal, and in that case, the surety defended a payment bond claim based on pay if paid language in the subcontract. And I see no reason why a surety couldn't also defend itself on a pay when paid if it can defend itself on a pay if paid clause. So in the private bond world, pay if paid and pay when paid clauses are defenses to sureties. In the federal contracting world, they're not. All right. Any questions on that case? And the last case I wanted to mention deals with the interpretation of a provision of the Commonwealth Procurement Code that's relevant to probably any contractor doing work on any type of public work in Pennsylvania. And the case is Burke's Products versus Arch Insurance. And in this particular case, Skepton Construction was the general contractor that entered into a contract with the Wilson Area School District. Skepton had to post payment and performance bonds because it's a public job. So it posted those bonds through Arch Insurance Company. And the language of the payment bond was sort of the whole point of the case. And so we've reproduced some of it here. And Skepton's payment bond had this clause in it. And you can read it, but we've underlined and highlighted some of the most important language. And as you can see, it provides that the payment bond remains alive and the surety's obligation remains alive until the principal, that's the GC, and any of the subcontractors of the principal have paid people they owe money to. All right. In this case, Skepton, the GC, entered into a subcontract with R.A. Tauber. Tauber bought materials from Burks. Burks is the plaintiff in this case. Skepton paid Tauber. Tauber didn't pay the material supplier and went bankrupt. Burks filed the only lawsuit they could. They sued Arch, making a claim under the payment bond. We don't have time to go through the entire Commonwealth Procurement Code, but there's two parts to the code, Part 1 and Part 2. Part 2 of the code contains all of the terms addressing payment, and it's very broad, and it basically applies to any public project, whether it's a Commonwealth agency or a governmental entity. Because this was a public school project, Part 2 of that code did apply. And Part 2 contains a section here, Section 3939, which everyone calls the safe harbor provision. And you can read it there, and what it says in its plain language is, if the general contractor pays everyone it's supposed to pay, future claims against that contractor or the contractor's sureties shall be barred. Okay, so in this case, the surety thought it was home free. The Commonwealth Procurement Code definitely applied to the project and the contract, and this clause has been in the Procurement Code since it was first enacted. So that was the defense to the claim. Said, hey, the GC paid the sub, just because the sub didn't pay the sub-sub, that's your tough luck. Go read the statute. Burks responded with the argument, hey, the bond is a contract, and the language of the bond itself is what you have to look at, court. In this instance, the general contractor and Arches, the surety, decided to issue a bond that had language much broader than what the so-called safe harbor provision of the Procurement Code called for. So that, hey, you've waived the protections of the safe harbor statute. Whether you meant to or not, you've waived them. Go read the bond, okay? The court agreed, and the court held that the language of the payment bond was broad enough that it waived the safe harbor provisions under the Procurement Code, okay? This case was actually decided in 2013. We discussed it briefly. This was important because the provisions of the Procurement Code are sort of incorporated into bonds by operation of law. It's a statute. It's going to apply to all these contracts. So there was an interesting legal question as to what was going to prevail here. An appeal was taken to the Pennsylvania Supreme Court. Supreme Court denied the appeal. They decided not to hear it, which means that right now the decision from 2013 on how this is going to be interpreted is the law of Pennsylvania. So the language in the bond may waive the protections under the Procurement Code. Why do we care about this? Well, this is unpaid subs and suppliers is a common problem. I mean, unless you're tracking it and you're a GC, you pay the sub all their money, you're assuming that perhaps they're paying their subs and suppliers. Unpaid subs and vendors are a very, very common problem in the industry. This is something that as a general contractor, you might not want to just say, well, we've posted a bond and we're good. You may want to take the effort to make sure that the bond being posted is one that complies with the Commonwealth Procurement Code to ensure you have those protections. I know that the AIA A312 bond, commonly used, goes beyond the safe harbor provisions. It's broader than what the statute requires. And I know Liberty Mutual and some of these other sureties have issued their own language modifications to that bond to try to fix that problem, but we're still seeing bonds where this is an issue. One note at the bottom, because we get this question a lot. I talked about CASPA a few moments ago. CASPA has a provision in it that says once the GC pays the sub, claims against the general contractor are barred, but it doesn't include the word surety. So this safe harbor provision does exist in the Commonwealth Procurement Code on public projects, but even though there's similar language, it's not the same, and the same protection does not apply to sureties on private projects under CASPA.